pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can I have a roll call of supervisors, please? Supervisor Ron Frederick, please. Thank you. Supervisor Celebrity is excused. Moving on to citizen comments. Any citizens wishing to speak, you have 5 minutes. Please state your name and address for the record. Any citizen comments? Any citizen comments? Seeing none, citizen comments are closed. Moving on to the announcement of the chairman, I would like to welcome the Youth in Governance. I'll try to say your names the best I can. Victoria Desmani from Legislative Committee, Andrew Hernkar from Legislative, and Tyler Andrews from Joint Services. Thank you and welcome. Glad you're here tonight. I also want to remind all the supervisors of the annual County Board Holiday Party, December 17th. Kemper, you could see the county clerk in regards to this. I look forward to seeing everyone there. That's all I have. I'll move on to supervisor reports. Supervisor Alverman, you have the floor.
Thank you, Mr. Chairman. I just have a couple small items. All of our projects that I've been reporting on, highway projects, are all still on schedule. We have still, although the closing of Highway W, we have looked into short-term fixes for the problems we have on the road there. We've got it closed from Highway F to north to about a mile from Highway 50. Short-term fixes on that are not viable at this point. We are looking at the long-term fixes that we can do, and there's a variety there. So Highway W is going to be closed for quite some time. The good thing that we do have going for us is the heavy summer traffic season is over. We do have very good detours in place. Wilmot Mountain is going to be somewhat put back by some of the traffic that usually takes W off of Highway 50, but as I said, there's very viable detours in place. So I'll keep you updated on that. As I said, we are looking at more of a long-term fix right now. Thank you.
Thank you, Supervisor Alverman. Supervisor Rodriguez, you have the floor.
Thank you, Mr. Chair. I just want to bring to attention to the county board and to the community about the programs Kenosha County has going on consistently throughout the year, 365, 24/7. It's the Kenosha County Suicide Task Force. You can call Kenosha County Crisis at 262-657-7188, or you can call the National Suicide Prevention Hotline at 1-800-273-TALK. I just want to bring this attention to the community, given recent events. Suicide's a permanent problem to a temporary situation, something, I think we've all gone through tough times in life, but you've got to look onward, look forward, and suicide isn't the best option, I don't think, in any scenario. On a lighter note, I want to bring to attention to my colleagues tonight and to administration and all county employees that this year Adopted Deputy was started by Ashley Busser. She's a dispatcher for Pleasant Prairie Police Fire and Rescue with the goal of honoring our men and women of the Kenosha County Sheriff's Department. It was started in light of the recent sentiment to police officers in the United States. The goal was to spread some hope, spread joy to the men and women faithfully serving our community, both inside the jail and out on the roads. From command shift to correctional officers, everyone is an important part of the Sheriff's Department. With the holidays approaching, many men and women will not get to spend time with their families. Being able to show these men and women the love from the community is something very special. There's about 300 deputy and correctional officers in total throughout Kenosha County, and the group here is asking those willing to participate and adopt one of the correctional officers or a deputy. There's, like I said, there's about 300 of them. They've got about 100 left. They're doing pretty well right now. You can buy a gift and you can drop it off at the Pleasant Prairie Police Department, and they will be dispatched from there come the holiday season. Otherwise, you can write a check or drop off cash, and they will get these guys something nice for the holiday season. Gifts range. Right now, people have been giving gift cards, movies, restaurants, spas, tools. I mean, anything you can think of. Myself, I will be adopting a deputy, and I would like to challenge everybody in this room tonight. I'd like to challenge administration to do the same, kind of show these men and women that we appreciate all they do for us. That's all. Thanks.
Thank you, Supervisor Rodriguez. Supervisor Berg, you have the floor.
For the past couple of years, I've had the pleasure of sitting in on the Kenosha County Opioid Task Force. And I say pleasure, that's kind of a bad word to use. But some of the things I've gotten out of this meeting kind of brings a lot out in terms of some of what's going on in our county. Some of what you might hear is, while there might be a small decrease in heroin deaths, there is a small decrease, but there is an increase in fentanyl deaths, and that's happening more across the country, that heroin deaths are going down because fentanyl deaths are going up. And one of the questions I asked somebody that was reputable that was there is, of the street drugs that are being apprehended, what percentage of those drugs, which includes marijuana, have fentanyl in them? And the number I was giving is astounding. It's 80 to 90% of the street drugs that are being picked up have fentanyl in them somehow. Something else that was brought up in that meeting is that there was an arrest here in Kenosha County a couple months ago that included 4 heroin or opioids. The children happened to be tested in that situation, and all 3 kids tested positive for heroin. So I think it's something that we need to continue to keep an eye out. Something else that was brought up in that discussion was everybody here, we talk about being trained in Narcan, and while being trained in Narcan is great, with the increase of the fentanyl, 1 dose of Narcan isn't going to help somebody that's overdosing on fentanyl. You need to make sure you have 2 doses. Obviously following that up with the 911 call, but be ready to administer that second Narcan. So that's all I got. Thank you.
Thank you, Supervisor Berg. Seeing no other supervisor reports, supervisor reports are closed. County Clerk.
County Executive Appointments, Robert Stoll to serve on the Kenosha County Zoning Board of Adjustments.
Refer to PDEC Committee.
21, Gregory Krushko to serve on the Hooker Lake Management District Board.
Refer to PDEC Committee.
New Business Resolution 1 reading, 47, from the Finance and Administration Committee, a resolution to accept donation of a parcel in Salem Lakes. Rose, yes. Ron Frederick, yes. Gens, yes. Poole, yes. O'Day, yes. Kubicki, excused. Wamble, yes.
Supervisor Rose, you have the floor.
Thank you. I would move the resolution.
Thank you. I have a motion by Supervisor Rose, a second by Supervisor Ron Frederick. Supervisor Rose.
This is the acceptance by this board, if approved, of a donation of a parcel of land in Salem Lakes. It's a 9-acre parcel which is landlocked by other property which is in the 100-year floodplain. It's really consistent with the county's longstanding policy to acquire properties which are in the floodplain, impossible to use for housing and other purposes, and it will just become part of other property that the county has similarly accepted or purchased in the past, which are also floodplain properties. So we're asking that you approve that this evening.
Thank you. Seeing no discussion, all those in favor say aye.
Aye.
Any opposed? Resolution passes.
Resolution 48 from the Finance and Administration Committee, a resolution authorizing transfer of a parcel taken by tax deed to the City of Kenosha and forgiveness of taxes and assessments. Finance, Rose, yes. Ron Frederick, yes. Gens, yes. Wamble, yes. O'Day, yes. Kubicki, excused. Poole, yes.
Supervisor Rose, you have the floor.
Mr. Chairman, I would defer to the Vice Chair, Mr. Frederick, to present this to the board as I was a dissenter on the proposition.
Not on this one, sir.
Point of order.
Yes, sir.
This is not that.
Yeah, this isn't the right, this isn't the one, Supervisor Rose.
Oh, I'm sorry. All right.
It's Resolution 48, if you'd like to move it, please.
All right. I would move that.
Thank you. have a motion by Supervisor Rose and a second by Supervisor Gens. Supervisor Rose.
All right, thank you. And this is also an acceptance of a piece of property which we would transfer to the city of Kenosha. This was taken by the county for tax deed. The city has plans to rehabilitate this. It's a good public purpose. It encourages ridding an area of a problem property, as it was reported in particularity to the committee and by Supervisor Wambold. And so it was believed that the city's proposal here to take it, demolish it, and rid this particular area of a possible drug house was a good purpose, and that the taxes therefore should be forgiven and the donation approved.
Thank you, Supervisor Rose. Seeing no discussion. All those in favor say aye.
Aye.
Any opposed? Resolution passes.
Resolution 49 from the Judiciary and Law Enforcement and Finance Administration Committees, a resolution in support of a multi-year cooperative agreement between Kenosha County, the City of Kenosha, and the Village of Twin Lakes for the Kenosha Drug Operations Group. Judiciary and Law, Boyd Frederick, yes. Wamble, yes. Celebrity, yes. Uhas, yes. Rodriguez, yes. Finance, Rose, yes. Ron Frederick, yes. Gens, yes. Kubicki, excused. Poole, yes. O'Day, yes. Wamble, yes.
Thank you. Supervisor Boyd Frederick, you have the floor.
Move Resolution 49.
Thank you. I have a motion by Supervisor Frederick, a second by Supervisor Rose. Supervisor Frederick.
Yes, this is a continuation of a agreement that's been going on for the last couple of years, where the KDOG, which is Kenosha County, works with the city and with the Village of Twin Lakes, works together with drug operations. And it deals with the asset forfeitures.
Okay. Thank you. We have some discussion. Supervisor Franco, you have the floor.
Thank you, Mr. Chair. I'd like to discuss a few concerns I have about this particular resolution. First, civil asset forfeiture as a policy has been highly controversial. In fact, advocates of criminal justice reform consider it as one of the several areas of reform and needed in policing. Historically, it began with the passage of the Comprehensive Crime Control Act in 1984 to deal with large drug dealers. Later, that particular policy had to be modified to address the overly broad application of confiscatory powers that it led to. This was seen in the passage of the Criminal Asset Forfeiture Reform Act passed in 2000, which did move the burden of proof from the individual to the state, but it still did not alleviate the abuses of the policy. One of the central problems with civil asset forfeiture is that, unlike criminal asset forfeiture, the claim is against the property, not the individual. Where relevant assets can be only confiscated in criminal forfeiture after conviction, in civil forfeiture, confiscation of property can occur without any criminal conviction or even criminal charges being brought against the individual. As a result, the Department of Justice Civil Asset Forfeiture Fund has gone from $27 million in 1985 to over $1 billion in 2008. Today, I'm sure it is much higher than that. Also, the practice of equitable sharing between the feds and respective states and local law enforcement functions as an incentive to continue this controversial practice. Fortunately, the state of Wisconsin received a grade of B from the Institute of Justice, a nonprofit libertarian public interest law firm. This was largely due to the fact that the assets seized in Wisconsin can only be spent on education and nowhere else. Consequently, there is a disincentive to abuse the policy in Wisconsin. This is a good thing, however. In other states where this is not the case, one sees the grades plummet. I also believe there are constitutional considerations with civil asset forfeiture in general. In fact, the most recent case decided in February of 2019, Tibbs versus Indiana, the court ruled that the Eighth Amendment's excessive fines clause is an incorporated protection applicable to the states under the 14th Amendment due process clause. Thus, grossly disproportionate asset forfeiture is unconstitutional. To make matters worse, assets seized through this practice do not have to be accounted for in budgeting. This is why there is no specific line item for it alone. Moreover, with this broad agreement, I fear the board will be relinquishing any oversight on this matter. In short, I have many philosophical and legal concerns with civil asset forfeiture. By agreeing to an intergovernmental agreement with the city and the town of Twin Lakes, concerns me greatly. This resolution is an attempt at circumventing the stricter state requirements in order to receive a higher percentage of federal dollars, and will ultimately create more incentives to increase the incidence of this questionable practice. This may seem to be a sound fiscal decision in the short term, but I believe in the long run we are simply incentivizing potential abuse. I hope I am wrong. However, I cannot encourage or promote the policy of civil asset forfeiture, and therefore will not support this resolution. Thank you, Mr. Chair.
Thank you, Supervisor Franco. Seeing no other discussion on this, there's been a roll call requested. Yes, if you're in favor of the resolution, no if you are not. Resolution passes.
Resolution 50 from the Finance Administration Committee, a resolution authorizing conveyance of property located at 11713 212th Avenue, Bristol, Wisconsin, to John Simmers, parcel 37-4-121-312-0272. Finance, Rose, no. Ron Frederick, yes. Gens, yes. Wamble, yes. O'Day, yes. Kubicki, yes. Poole, yes.
Supervisor Ron Frederick, you have the floor.
Move approval of the resolution.
Thank you. I have a motion by Supervisor Ron Frederick, a second by Supervisor Gant. Supervisor Ron Frederick.
Thank you, Mr. Chairman. This is an unusual thing that we're trying to do here tonight. I think that they say there's no precedent for it. Well, I can attest to you that there is precedent for it. In fact, when I was treasurer way back and farther back than I care to admit, we had a property that I tax deeded because I couldn't get through to the owner. I went out there, post office box, it was some farmland, and I finally had to tax deed it. When I did, the family found out that the gentleman was farmer who had some mental problems and just ignored everything in every letter that I sent him. This is a case of a person who I think had some issues relative to it. I can't say that for sure. It's kind of an emotional thing when you take somebody's property. And they came to us last Thursday. It kind of came out of the blue, and they asked us if there was some way that we could get it back to him because he's running on an eviction notice right now. And the Finance Committee had a long discussion on it tonight, and there was all kinds of reasons the Corporation Council said we're setting a precedent, and I'm suggesting that it's giving a person his property back as a precedent. I'm happy to sign on to that. So I voted for it. As you see, the chairman voted against it, and I'm recommending that it be approved. And if anybody has any questions, feel free to ask.
Thank you, Supervisor Frederick. There is discussion. Supervisor Rose, you have the floor.
Thank you, Mr. Chairman. And I oppose this in committee and urge the board this evening to oppose the resolution here, which I believe sets a very poor precedent and a very poor standard, particularly for the many people who pay their taxes on time in this county. What was the county's policy in 1989? We had a policy at that time where property was tax deeded. It was possible for the taxpayer to come forward and pay up the taxes, even though the county had taken the property by tax deed. That ordinance was revoked in 1993. So in 89, it was adopted. In 93, it was revoked. So what is the current position of the county with respect to paying back taxes? In the revocation of the ordinance in 93, I think it says it very loud and clear that the policy of the county is if the county takes it by tax deed, you're too late. Now, a taxpayer such as the one mentioned here has had many opportunities to pay up. Could have set up a payment plan, time and again, but it went to tax deed. Mr. Moyer then commenced an eviction action against him, and it was very difficult to serve him. And if you look at the record that was presented to the committee, you will see that the individual, even though his car was in the driveway, would never come to the door to accept service of process. So the matter is now in the small claims court for an eviction action. If this resolution passes, of course, that would be set aside. So this person has been given ample opportunity time and time again to pay the taxes, avoided service of process, avoided coming to the county clerk's office, paying up in full, and we're talking about to date some $16,000 plus. Never paid it. Never set up a payment plan. Never ignored the process server when papers were going to be signed. Ignored letters which were sent to the house. But let's take a look at the entire history of the property, which was inherited by him in 1993. He has never once paid the taxes on time. The record presented to the committee was that every single year he has been delinquent. Where does the sympathy here lie? Now, it has been mentioned that he had some health problems in 2005. I don't know what that's all about, but I do know that since he inherited the property in '93, he has never paid taxes on time. Now, what is the board's policy here? We revoke the policy in 1993. We revoked the ordinance. If we grant the motion tonight, are we going to have a flood of these kind of things? Are we going to be able to sort out, this one is sympathetic, that one isn't sympathetic? This one has a divorce problem, somebody else has a financial problem, somebody else has a death in the family, somebody else has some extraordinary event. What's the criteria? A developer comes before our committee and says, well, we couldn't pay our taxes because we wanted to develop this piece of property and we were paying for this issue and that bill and another bill, presents a development that looks good for the county. Is that a sympathetic thing, that we are financing that developer? Or are we going to say, no, well, you're just in it for profit? The next guy next person comes before the committee and this board and says, well, I had a death in the family or I had extraordinary illness. Does that meet criteria? I don't know what the criteria is. There are many people who have gone to the clerk's office, I understand, and have wanted to do the exact thing that is being asked of this board this evening and have been turned down again and again, and they never came to the committee. This person happens to come to the committee. What about those people who read in the paper tomorrow morning, if this resolution passes, that the county allowed it there? Are we going to do some reconsideration there? Since they were turned down in the clerk's office, didn't know that they had the opportunity to come before this board and to plead their case. If we're going to allow payment of taxes which have been taken by tax deed, when is the cutoff date? Again, we have no policy on this. Is that going to be all the way up until the time that judgment of eviction is entered and papers are turned over to the sheriff's department for forcible eviction? I don't know. But I think we are setting a very, very poor precedent here. And I ask, what about the people who do pay their taxes on time in the community? And what about all of those people who have come to the clerk's office and said, in like manner, I had a problem, can't I solve it now because I've got the money? I think you have to reject this kind of resolution based on the proposition that we do have a policy. The policy is you don't pay your taxes, it's going to be taken by tax deed if it meets the standards and criteria, and you're not going to be able to pay it back because that's what the board said in 1993 when we revoked the 1989 ordinance which allowed for repayment of taxes. Thank you.
Thank you, Supervisor Rose. Supervisor Gens, you have the floor.
Thank you, Mr. Chairman. I will not go against the fact that we got a lot of different opinions back and forth. We shouldn't do this, the policy, the precedent, but we have taken partial payments, and the clerk explained to me that it was because we could take them before the year went out and it would reset the situation. But what we're doing here is we're taking everything all the way back. Whether you believe him or not, he did have issues, and he did respond to one sheriff's summons. It's a unique situation, and so to have the chairman of finance, I can appreciate his fervor with this, but we got to hear the whole story, and the committee voted 6-1. So I do agree, though, that we need to have a policy set, and we did put that on our next agenda. So we're not trying to just cherry pick who we want to feel sympathetic to or not. We want to get a policy laid up. I was not here in 1993, so I don't know what was done away with. I'd like to see and hear that and see where we go from there. But we are going to look at it. We felt it was the right thing to do. It did pass the committee. That's all I have. Thank you.
Thank you, Supervisor Gens. Supervisor Rodriguez, you have the floor.
Thank you, Mr. Chair. A few things with this. Going off of what Supervisor Gens had just said, and going off of what Supervisor Gens has just said, that there needs to be a policy in place. Finance is going to take a look at that at what sounds like their next meeting. We don't want to cherry pick. What this does tonight is cherry picks this one individual case, and based off what the chairman of finance has said, this individual has had issues for decades paying his taxes on time, and to me it sounds like he's been calling our bluff about us taking his property. He's got to play by the rules. There's rules set for a reason, and I don't think it's fair to the rest of the community to say, well, you don't get to pay your taxes on time or not pay them at all, but then once it starts getting serious and once we're about to take your property, now you can pay it. I mean, what this gentleman is doing, in my opinion, is he called our bluff for decades, and now it's finally hitting him that this is real, and he's going and he's asking the clerk, and then he came and he went to the committee, and the committee feels sympathetic. Don't get me wrong. I would hate to kick somebody out of their home, but you got to pay your bills. And just coming up now and saying, too little, too late, I'm sorry, and if we want to start doing this again, then maybe we wait until there is a policy or not in place. With that, through the chair to Corp Counsel, does this, in your opinion, set a precedent?
I'm going to defer to Citizen Corporation Counsel John Moyer, only because he's been working closely on these issues, and if I feel I need to add anything, I shall. And
real quick, in our meeting this morning that I had with John, could you please bring the whole entire board up to speed on what we talked about so everybody has a clear picture? Because I know some supervisors weren't at finance. Can you just tell us from day one the process with this event, please? I would appreciate that. That way everybody here gets a clear and concise view of what's going on. Thank you.
So Mr. Simmers has resided in this home, as Supervisor Rose said, since 1990, I believe since 1993. He appealed asking that after the tax deed was actually taken, which was in August of this year, that be set aside. He said that it should be set aside because the assessment was faulty. One of the pillars of our system is, and it's constitutionally based, is uniformity of taxation, and that is my concern with this case. If we set aside the tax deed here on a subjective basis because of a sympathetic set of facts, which I'll grant, I think there's a certain amount of sympathy anyone can feel for anyone losing their home, and certainly Mr. Simmers is no exception. He's a good person, he has a lot going for him. But if we do that and we have a subjective analysis in terms of giving back someone's property after a tax deed, after all the opportunities they have that were alluded to by Supervisor Rose, the multiple notifications, the payment plans which the statute allows to be given by a treasurer, that's statutorily based, that there can be a payment plan. In the case of Mr. Simmers, where there's a mortgage, there's no mortgage, a reverse mortgage could be entered into, and that money could be used to pay off the taxes. Once we set down the slippery slope of making subjective judgments on individual people and their situations to undo or walk back or rescind a tax deed, I think we're entering very dangerous territory. What happened with Mr. Simmers is he was given all the proper notices. He's not denying that the notice was proper, that there was anything done wrong by Kenosha County. No, to the contrary, everything was done according to law. And it was after the tax deed was taken and the eviction was filed, a 28-day notice, that Mr. Simmers became concerned that he obviously was going to have to leave his home. No one wants that to happen to anyone, but in this situation, that's what the law, that's the remedy the law provides. And it was at that point in time in which he then appealed to Supervisor Uhas here, and then also ultimately to the committee, the Finance Committee, to ask that it be reviewed. So in terms of the process, that's what happened to get us here today. The committee voted in favor of returning the property to him. I would just indicate this. There has to be a basis in the law in order to rescind a tax deed, either a notice defect, which he concedes is not present here, or an inequitable tax. That is, that the assessment was in error. It is that which Mr. Simmers claims here, that the assessment is in error. And the problem I have with accepting that is there's no evidence that the assessment was ever challenged. There are lots of ways under the law that you can challenge an assessment. You can go to a board of review and you can go to a court. And to my knowledge, based on the concessions made in the committee meeting today, there was not even an assessor to the home to look at the condition of the interior of the home. I do know that the property is valued at $75,600 divided between the land, which is assessed at $37,200, and the improvements, which are $38,400. So what Mr. Simmers is positing or suggesting is that that $38,400 assessment is inequitable, that it is unfair. I don't know if it's unfair or not, but there's certainly no proof provided in what I've seen from his materials that is in support of it being inequitable or unfair. And absent that, I know of no reason other than some subjective judgment, which opens a Pandora's box of deciding which problems of an individual, personal problems, are going to be enough to arise to the level where we want to rescind or withdraw the tax deed. That is the concern I have. I think it's one that goes to the uniformity of taxation, to basic fairness to those who do pay their taxes on time. There are many people that struggle to pay their property taxes. Many of them make payment plans. Many of them have a lot of trouble doing so. But to wait until after the tax deed is taken, after all the notices go out, after a person is told perhaps they can do a reverse mortgage, they could take out a loan, they could make a payment plan, I don't think it's a good precedent. I don't think it's a path down which we should walk.
Can you speak to the Supervisor Rose? Can you speak to the years past, what we spoke to this morning, like 2005, 10, so on and so forth? And I want this body to understand that the county owns this property right now on tax deed. It isn't being taken. Correct me if I'm wrong.
Correct.
It's been taken. The county owns.
It has been taken. The county now owns this property. So what we're doing is we're backing the train up and the train's down the tracks. The county isn't in the process of taking it. The county now owns this property. And that's a big deal. So I just want everybody to be clear on that.
And you want me to go through the history of?
Just what we talked about this morning. I just want everybody to have the best informed decision, that's all.
I do know that, that in 2005, I was told that a final notice went out to Mr. Simmers. That is that we were ready to tax deed the property at that time. And he did pay enough taxes to get back to being outside of the box, so to speak, of eligibility for a tax deed. That happened again, I believe, in 2010, and I'm looking for my notes to be certain, but I believe it was 2010, and I believe it happened again in 2018. My understanding of the records from the clerk of the county is that there have been, this is the fourth time that he has been in a position for a tax deed to be taken, and this time it actually was taken. But there has been a precedent for him being eligible for a tax deed falling that far behind, which requires 2.5 years of tax delinquency. And I can also indicate that he has not ever been current on his property taxes since he's owned the home. So.
Okay. So Supervisor Rodriguez, you still have the floor.
Thank you. I think based on what we were just told, I mean, this just goes even more so to the point that to me, it sounds like this individual has tried it every step of the way for nearly 30 years to not pay his property taxes, and it's gotten to a point now where it got real, and to the point of the property owner saying that there's a fault with how his property was assessed. This resolution would have him paying the back taxes, paying the fees, and by doing that, he'd be conceding that the assessment was correct. And I mean, there's a hole right there. I'm not going to keep reiterating myself, but his time has been here for 30 years to pay his taxes on time. He's continually not done so, and I don't think he should be given another chance after he knows how the processes work. It seems like he's been through it multiple times. Thank you.
Thank you, Supervisor Rodriguez. Supervisor Ron Frederick, you have the floor.
Well, I just got two lawyers telling me I'm wrong, but okay. So what the proposal says, if you want to know about the property, you probably should. It's built in 1944. It's a single-family ranch, 720 square feet. It's no castle. One bathroom and gas heating. If you vote for this resolution tonight, he will have to pay $16,702.10. Now, I recognize the arguments that we're setting a precedent. Someone said, well, what if other people come on? And my answer to that is one at a time. You can vote on them one at a time. There's no law that says we can't do this. Okay? So whenever they come before us, they'll have to give us reasons, and we can do them one at a time. I don't want to throw this guy out in the street. He's a veteran. He had some mental issues. I don't want to go into that because that's, but what I listened to at the committee meeting, this guy had a hard time, and it was mental, okay? Just as like the property that the county gave back in 1989 when I took a tax deed on a farmland. So do what you will, but I'm just going to say this, one at a time. Not setting a precedent. You're setting a precedent. You could vote on this one. The next one comes up, we'll look at it. Thank you.
Thank you, Supervisor Frederick. Corporation Counsel, do you want?
And I just do want to say in response to that my concern, and I expressed this in front of the committee, is that to say we will take these one at a time is actually maybe what scares me more than anything else, because I believe that it runs the very real risk of opening us up to a claim that we are capriciously and arbitrarily making a determination on these matters without having some sort of consistent set of factors that we are deciding on. And that the next person that we say, sorry, your set of circumstances wasn't quite sympathetic enough, is then going to take us to court to say, well, how come they got this and I didn't? That's my concern. That's my worry about doing these on a case-by-case basis.
To the chair,
Yes.
may I please just correct, just for the record, I want to make clear, I've got my notes here. It was 2010 during which Mr. Simmers received a final notice for the 2007 taxes. The county pulled a letter report, and he then paid off those taxes in November. In 2015, he was sent a final notice on his 2011 taxes. He paid those off shortly thereafter, and in 2018, he paid off the 2014 taxes. So those are the dates that are correct as to the 3 prior times we nearly came to a tax deed in the past. Thank you.
Thank you. Anything else, Corporation Counsel?
No, thank you.
Supervisor Poole, you have the floor.
Thank you, Mr. Chairman. As has been stated, this is no castle, $75,000 home. He owes $16,000 in taxes. And, we don't know the condition. We could easily spend half of that $16,000 to have to demolish it or rehab it. And this is a veteran with medical issues, and I think we just need to end it now and let him have it back. Thank you.
Thank you, Supervisor Poole. Supervisor Grady, you have the floor.
Thank you, Mr. Chairman. Just a question through the chair to Ron over here on committee. In terms of his claim that it was improperly assessed, I'd like some clarification if he brought in evidence of that to the committee. And then also going forward, does he have the capacity, the means, Mr. Simmers, to basically purchase this back, pay the taxes, we don't have to revisit this thing again? I mean, what is the status with that? I'd like some clarification, please.
Hold on 1 second, please. Go ahead, Supervisor Frederick.
He will need to pay this by November 30th, and then it would be quick claim to him at that time. If he doesn't come in with the $16,700, whatever that is, by November 30th, all bets are off.
And that would be paid back in its entirety then, that's the statement?
All the back taxes and penalties.
Plus penalties. Plus penalties, yes.
Yeah, well, the penalties are in that 17,000, or the interest. He's paid that 17,000, probably if he would have paid it on time, probably would have been more like 8,000, so. But that's that, yeah, you know, there's a concern here, but I just think it's the right thing to do, and I think we can take them one at a time.
Well, my comment is this.
State your point, sir.
Please do so.
Okay. The gentleman was living in this 700 square foot house. He had one bathroom and one bedroom that were functioning. Okay, a lot of the time he was afraid to answer the door because of how much he owed and because he thought they'd kick him out of the house. He had a lot of medical problems. He has since had some veteran buddies of his, one the attorney he's with here tonight, that have stepped forward and said they're going to rehab the house with him and make sure that he stays in a positive financial position. So obviously that remains to be seen, but it's interesting that we could sit and make a decision on that without hearing all that testimony as well. So I think those are the two questions that you asked, and I just wanted to give you those answers.
Thank you. Then I'll offer the following comment. To each rule, there always are exceptions. This may be one of them, and if the committee process worked in the manner in which it did, and we had the majority of the committee in favor of it, I will support it as well. Thank you.
That is Supervisor Grady?
That's it.
Thank you. Supervisor Gens.
Thank you, Mr. Chairman. I do understand the policy and the procedures and the precedent, and that's why it is on our next agenda to look at it. So we will, I mean, I'm telling you, I agree that we should have some type of policy in place. We are going to look at that, get all the information from staff, and make the best decision at that point and move it on to you guys at that time. But that's just, I wanted to address that too, so thank you.
Thank you. Supervisor Gaschke, you have the floor.
Thank you, Mr. Chair. I have nothing but sympathy and compassion towards Mr. Simmers, but I want to speak on this issue a little bit more broadly than this particular individual situation. As others have mentioned, I do believe that voting in favor of this tonight would set a poor precedent, would potentially open us up to future litigation, and I, for one, don't believe that we're qualified, nor is it our job to sort through each individual case one by one. Therefore, I will be voting against this tonight, and I urge the rest of the board to do the same. I do think that if we as a body want to reconsider the policies that we have in place, that would be appropriate to do. However, I think moving forward on this tonight and then changing our policies after the fact is putting the cart before the horse. And as has been mentioned, would be too little, too late. I think we need to work within the framework and the structures that we have in place, the policies that we have in place, in order to be fair to everybody within our community. And again, therefore, I will be voting against this tonight and urge the rest of the board to do the same. Thank you.
Thank you. And I want this body to understand that it was brought up at committee, and correct me if I'm wrong, Corporation Counsel, that there could be an extension of this, potentially? We could look at our policies, is that correct?
If this body chooses to, for example, table this, yes, there is the possibility of, and I would, representing the county, adjourn the eviction matter. It could be done until January. I think the concern of the committee, and I don't want to speak for them, if I'm wrong, please correct me, but I think the concern of the committee was legally there's no way to stop the interest and penalties from accruing if we do that. So the bill is going to be higher come January if we decide that the policy should change and the property should be given back. The penalties and interest are going to grow, and I think that was the concern of the committee as to delaying this. But yes, from the county's perspective, we would adjourn the eviction action and allow Mr. Simmers to remain until January, at which time then there might be a decision on whether the policy ought to change or not.
Okay, thank you. Supervisor Berg, you have the floor.
Just to start with, I will be supporting this. Somebody spoke earlier about him not coming to the door multiple times. I get it. However, when the sheriff's department did put it on his door, he did take it off and he did call the sheriff's department, ask them to come back and serve it. In terms of what was mentioned earlier about the 2005 health problems, you don't know if this gentleman sat on his health problems for 12 years since he got the house. He may have sat on those health problems for 12 years. Thank you. Veterans do that. They sit on their health problems. I can attest to that myself. Cherry picking, absolutely. I'll cherry pick for a veteran if that's what it means. I've been in the military for 20 years. If you're willing to have a 42-year-old full bird veteran stand up for him and try to help him through this process, I'll do the same. In reference to the question that was asked earlier about when is he going to pay this, he already tried giving a check today to the treasurer at committee level. So I expect that he'll be down there tomorrow morning to pay that. So with that, I'm going to be supporting it. And if anybody does table it and there are penalties and interest incurred for the next 2 months, I'll be the first one to donate towards paying that. So I'll be supporting it.
Thank you. Supervisor Rodriguez, you have the floor.
Thank you, Mr. Chair. Through the chair to Attorney Moyer, when was the first instance of delinquent taxes, whether not paid or paid partly, or paid in part rather, since he took ownership of the property?
My understanding, based on the report from the clerk's office from records, is that in 1994, at that early date in terms of his ownership starting in 93, his delinquency or falling behind unfortunately occurred in 1994. So the reality is, unfortunately, that Mr. Simmers has never been current on his taxes since owning the property and going forward 94 beginning.
Okay, thank you. I just want to, my concern here is, say he cuts us a check, he gets his property back. What is to say this doesn't happen to us again 2.5 years from now when he hasn't paid his taxes again? I mean, what's clicking on that? And to go off of what Supervisor Berga said, I mean, I'm sympathetic. He's a vet. I get that. My brother's in the Marine Corps. My grandpa was in the Army. I mean, I got a long history of U.S. military service throughout my family. But, I mean, are there other laws then that because somebody is simply a vet, they can choose to ignore? That's my question. And, I mean, we've got 2 attorneys that represent the county, a 3rd attorney amongst us who is saying this sets a dangerous precedent. And those of us who aren't attorneys are somehow deciding we know more than these attorneys in this room. They're telling us this opens a Pandora's box, this is not a good idea, and until there's further action on the county's part, I mean, we shouldn't be doing this. And going off, I mean, what they're going to be talking about in finance, I wouldn't even support bringing back a system like this where, it's about to be tax deeded, now you can get on a payment plan, you can do this. You've had your chance. You need to play by the rules, that's why we have them. And for those reasons, I won't be supporting this, and I don't think any of us should be.
Thank you, Supervisor Rodriguez. Supervisor Sklitsky, you have the floor.
Thank you, Mr. Chair. The question I had was one that Supervisor Rodriguez just mentioned, and that was, what is the plan moving forward if this occurs in 2 years from now, or next year, or the year after?
Sir, I don't believe there is one. We take it back. Right. That would be the,
That's what we're proposing right now.
excuse me,
And yet-
Supervisor
oh,
Sklicki.
sorry.
Maybe county, you want to add, let's have the county clerk.
I was just going to comment that if Mr. Simmers goes back to the same pattern that he has in the past and doesn't pay the taxes in 3 years, 4 years, we'll be right back here again where we'll be taking the property.
Thank you for clarifying. So, a single occurrence is just that, an occurrence. However, this has been a trend that has been occurring over and over and over. I had the utmost sympathy and respect for Mr. Simmers, and given that fact that he is a veteran, but he has had the property since '93, and the only mention of health issues comes 11 years later, and yet this trend has been followed. I'm very much so torn, and I do appreciate everybody's comments, insights, clarification tonight, because I think there's a number of supervisors that are right down the middle on this one. We have to follow the current ordinances, policies, procedures as written, and then if we don't like them, we can amend them into the future. But right now, we're trying to make an exception for one individual who has a long history of not following what the process has been put into place for centuries or certainly decades within the county. So what do we say with the single mom and 2 kids loses her job? And the economy turns down like it did during the deep recession. She can't pay her taxes. Is that qualify? Where do we draw the line? What is or isn't justifiable for this? I think that it's such a broad topic that other than following the current plan as written or requirements as written, it would be endless to try to define what is or is not justifiable. I don't think the county has enough resources within the Corp Council's staff or even outside counsel to handle that many examples, and it would tie us up for an extended period of time. I did hear the proposal about potentially tabling this issue, but again, all it does is delay it for a couple months, but really doesn't resolve the issue. The issue is we have an individual within Kenosha County delinquent on his taxes, not once, not twice, multiple times, and then at the last minute, more or less games the system in the county, comes in, pays it, and starts the clock all over again. And this whole time, we cannot just point to health or mental issues. That's not possible, because he'd be in a much worse situation than he is. I do appreciate the fact that we are a compassionate board. We tend to try to work out reasonable solutions to this, but we also have to look at the reality of all the other taxpayers and the property owners within Kenosha County that do pay their taxes on time. And what is the signal that's being sent to them? Well, just don't pay them. Don't pay them, and eventually the county will probably give you a dispensation and a special situation, and I think that's a dangerous situation to get in. So I am very much so sitting on the fence, and I think there's more than one of us sitting there like so. But given the current situation, I'd have to vote against this resolution only because of what it could lead to down the road. So I don't know if my thoughts and position can help any other supervisors on their vote, but that's where I stand right now. Thank you, Mr. Chair.
Thank you. I think that was very well said. Supervisor Alverman, you have the floor.
Thank you, Mr. Chairman. I've been through this once before, and I'm not sure what year it was. It has to have been after, well, I didn't get here till '95. Very nice home, 1 block off the lake in Twin Lakes, where the wife secretly had a gambling problem, did all the mail, and the husband never knew, and she hid the notices, and his family had had the house, a summer home in Twin Lakes for 60-some years, and they lost it, and they came to our meeting. It was one of the horrible nights that I've sat through. You are compassionate. We're all here for a reason, because we like to be involved. Supervisor Geschke said very well that are we qualified for something like this? And I think the best remarks have been from Supervisor Sklitsky. I personally think we would have to have the Gates Foundation once we did this, because we would be inundated. That was a horrible night I had to sit through back then, and people are going to feel that way this evening. We aren't qualified for the box that we would be opening, the lid that we would be taking off. I know a lot of people, and so do you don't realize it, that are in trouble with taxes. If you read the paper, I think it's published each year, there's been real estate guys that have played the game forever. I see the same names going down the line. I know them. Some of them are very successful people. They do it constantly. It's been done since I was born. But are we qualified here to sit and pick each case? No, we're not. The reason that ordinance was changed is it didn't work. That's why it was changed. And this policy, I guess none of you have ever sat through anything like this. I did it once. I don't know if Terry was in that meeting or not. But it seems to have worked. Most people do pay them. They play that thing up to the 3-year period. It's the 4th year where it happens. So I couldn't support this evening. I could. One thing I could say is if we would table this, I don't know who we'd have work on this and come up with a workable ordinance. I think it's a non-workable situation. We are here to represent every citizen in Kenosha County, and that means treating everyone the same. And if your neighbor pays his taxes and you pay your taxes, and we start doing a lottery of 16 people this year don't have to pay their taxes, we've got nothing but trouble. It's sad to say. I think everyone would like to vote yes on this, but I can't see a way out of it. Thank you.
Thank you, sir. Supervisor Rodriguez, you have the floor.
I don't have anything.
Okay.
Thank you.
Thank you. Supervisor Frankel.
Yes, thank you. I think all of us are struggling with this particular resolution. I can see definitely both sides of this, but the one thing that sticks with me is even if we did table this and wanted to come up with an amended policy in regard to this particular issue, I don't know what it would sound like. How would we know which, for lack of a better word, sympathy exceptions would qualify? How many would there be? Under what criteria would we determine? I think I agree with Supervisor Elverman and Supervisor Sklitsky and others who've already spoken. I can't envision what this ordinance would look like, and maybe it's not something that we could even come up with a workable solution to this particular problem. So I just don't see it, and we'll be voting against this resolution.
Thank you. So right now I'm going to clear the board. There's lights all over the place here. So let me clear the board, and if there's any other supervisors that want to have discussion, Supervisor Gens.
Through the chair, I would like to ask the individual who we're talking about tonight or his attorney if they'd like to come up and make a few comments. Or I can ask them specific questions if you would feel more comfortable doing that. But, I mean, we're judging his mental state and talking about all this stuff and bringing up meetings we had about all the past years. So I would like to at least have them have the chance to at least speak.
I'll allow it.
Thank you.
If you'd please come step up to the podium.
Thank you for allowing me to talk. My name is Robert Hashimoto. I'm a retired colonel in the Marine Corps. I'm not an attorney. I'm a personal friend of Mr. Simmers, and I would like to address a couple of the issues that were brought up. One of them is that he's gaming the system. I don't believe he's gaming the system. What happened is he's disabled, and he had long-term disability, which was revoked in 2008. So he had to struggle between the choice of getting his medicine or working on his house. He had to make difficult decisions there. So he suffered with depression and had problems managing things. But that has persisted through this. However, in spring of this year, I think it was March or April of this year, he was the recipient of a medical grant to pay for his medication, which now allowed him to divert his money into paying his taxes. And that's what he was trying to do. Now, his error was that he was trying to also coordinate with the Village of Bristol at the same time because he has citation for paneling on the outside of his house. So, as a veteran, he feels a responsibility. His priorities are maybe a little bit backwards because there was a citation. And that's what caused attention, so he diverted his attention there. I will tell you that he is a responsible individual, and he does have a disability. He does now, he admitted to his friends that he has this issue. We just found out about it last month, and we're willing to help him. But he will have the ability to carry forth in the future because of the grant, and he does have an IRA that he will be able to use. Now, when I asked him why he didn't get help before, he's going to responded with the comment, like most the veterans would, that's only for people in real need. You know, he wouldn't take that. He's too proud. But I would like to see if he had something else to add to that, if that's possible.
Hi, I'm going to ask up front that you excuse my speech here, but I think I can communicate. Colonel Hashimoto was not nice enough to come to speak on my behalf, but I think I need to address, and I understand some of your justified concerns as far as paying going forward. I'm sorry. As far as the payments in the past, it's as Colonel Hashimoto expressed. It wasn't an overnight thing that happened. It was a gradual thing that happened. And I not only paid the taxes in the past, but I paid all the penalties, interest, fees, whatever was there that was due. When I came to pay, I didn't dispute any of it. I paid it all. So I hope that addresses that, and I understand the question, is he trying to game the system? I'm not. I'm just trying to get by. What did happen was, and what I'm asking for is consistent with something that already exists. It's not something that you have to create. There is a Wisconsin Supreme Court case that addressed the issue of setting aside a tax deed. It was Jackson County that actually brought the suit. In that particular case, and Attorney Moyer is familiar with it, so I ask, because he's the expert, to correct me if I'm wrong, but in that case, Jackson County, I will call the one of the defendants in the case Jackson Landfill. Jackson Landfill stopped paying their taxes, and Jackson County issued a tax certificate, just like similar to my case. Jackson Landfill, in I believe it was 2000, they had filled the area of landfill that they had dedicated for waste, and they continued to stop paying their taxes. And in approximately 2002, Jackson County took a tax deed. Well, when they did, they were unaware of a contract that Jackson Landfill had with the Department of Natural Resources that enforced payment for maintenance and long-term maintenance of the landfill. And it was exorbitant cost
it became an exorbitant cost to Jackson County. So Jackson County tried to rescind, they voted on a resolution, and they wanted to rescind the tax deed. Jackson Landfill didn't want the land back, and so they refused to accept the rescinded tax deed. And the question before the court then was, well, can a county rescind a tax deed once it's been taken? And the Supreme Court said, no, you cannot rescind, but you can set aside for certain circumstances. And the circumstance was particularly when it affects what they call the groundwork of the tax. Now, the groundwork of the tax is the assessment process, not the dollar amount of the assessment, but the assessment process. If the process is flawed, it's called a defect in the groundwork of the tax. In my case, there was a defect in the groundwork of the tax. It was discovered after the fact. What the defect was that in 2005, I took a building permit out to renovate the home completely. As it's been noted, it was built in 1944. It was due for an overhaul. I gutted the interior, and the copy of the application that I submitted to the committee with other material reflects that it would have taken effectively to gut the interior of the home, which I did. At about that same time, the effects of my disability and the co-pays that I had to make had me facing some decisions. I stopped any construction on the home. It was virtually stood that way since around, at least 2008. It's been completely, the interior has been pretty much a void, except for a small area of the home that I live. It's a small room and a bathroom. I was asked in committee why I didn't challenge the assessment, and I could only state from my personal point of view, but one that I think others would share in my particular case, is that I was afraid that if I brought it up, that I would be taken out of the home because it was unlivable. But you see, it was just me living there. I learned how to live there. So that's the reason why I didn't challenge the dollar amount. But this particular case that already exists, the means to already exist to set aside a tax deed, has to do with the process. As we verified in committee, no one has ever assessed the interior of that home in the relevant time. No, so imagine your home with 75% of the interior gone, and somebody comes by and assesses it without ever seeing the inside of the home. Common sense, reasoning, just common reasoning would tell you that that's obviously going to vastly affect the principal amount of the tax that is assessed. And under that circumstance, the circumstance that exists in my house that we, again, verified at the committee through a number of statements, no one has been inside this home to look at it. Then, therefore, you have grounds to set aside the tax deed. You're not setting precedent. It's already established in case law. What I'm asking for through this resolution. And with that, if the chair would allow, I'd be happy to answer any questions that might be with the chair's permission.
Okay, sir. Thank you. I don't think we have any questions.
Okay.
I appreciate.
I still have the floor, and I just wanted them to get their
Yes,
point
sir.
of view out, since that's what finance heard, and I just wanted everybody to hear it.
Sure.
Thank you.
Sure. Thank you, sir.
Thank you.
Supervisor Gent, you still have the floor.
No,
That's
that's
it?
fine.
Okay. Any other supervisors have any comments, questions, concerns? Supervisor Sklitsky. You have the floor.
Mr. Chair, I'm not sure where to direct it, and maybe it's to Mr. Simmers himself. Does he feel confident going forth now each year that he'll be able to meet his tax obligation?
I'll allow that. Mr. Simmons, can you please step up to the podium?
Yes. I understand that question, and the answer is yes, on three fronts. One is that I've been granted assistance through an organization called the National Organization of Rare Disorders, and whatever my Medicare does not pick up, as far as my medications are concerned, they cover or intercede to bring it to zero. So, for instance, I was granted that in April of this year, and a rough calculation, my medications are $96,000 so far this year, which insurance has taken a great degree of, and I submitted this documentation also with my package to Finance. I believe a good calculation that since April of this year, they've paid $8,000 that I would have had to otherwise find a means to pay. They're keeping me every month with my medication, so I'm a little more functional. So that is through December 2019. They have an automatic renewal, and that's just to verify that I continue to be eligible for their program. They're a great organization. The other thing is that in March of this year, I became 60 and a half, which means that the retirement fund that I have set aside, that I also provided documentation to the Finance Committee, is available to me without heavy penalties and heavy fees, etc. So I can withdraw on that at any time that I wouldn't have the funds available. And the third thing, as Colonel Hashimoto, I'm feeling the wrath of my friends for not having let them know about my situation earlier, and I can only say that I know their word is good, and they're there for me as a third option. So yes, I do have a plan in place going forward.
Thank you, sir.
Thank you, Mr.
Thank you, Mr. Simmers and Mr. Hashimoto, for your service to this country. And boy, this is really a much different situation than I had just been speaking about. The last thing I want to do is create another homeless vet. This individual is in his home. Obviously, these are some very different circumstances, one of which, or many of which, have been now resolved. I think I've just changed my disposition, and I'll support this resolution, because the last thing I want to do is see a veteran put on the streets. We have too many right now, and too many other needs in this community. Although I know I'm just backtracking here in my own words, but I can't help it. Here's an individual that has earned the right and the support of the community. On the other hand, I certainly can see all the legal aspects that could be concerning, but this one does seem exceptional. So thank you, Mr. Chair, and I will support the resolution.
Thank you, Supervisor Klitzky. I just would like Corporation Counsel, John, if you can step up, and can you speak to Mr. Zimmer's regards to this court, Supreme Court?
Sure.
I mean, I just want the board to. This is extremely tough, sir. I mean, there's not a person in here that is not behind you. I want you to understand that. The character of every man and woman in here tonight is 110% behind you. I want you to understand that. This is why we're taking the time to do this. And it totally breaks my heart to see that you're going through this. It does. But I think that we all have to make the best informed decision on what we need to do going forward, okay? Can you?
Thank you,
give us some insight on that, please?
Mr. Chair. I would just say this, without a policy, without that ordinance in place, and perhaps it's the intent of this body to put such an ordinance back in place, I don't know. But without it in place, I don't know that there's legal authority to undo the tax deed here. And I've read the Jackson case that's been referred to from our state Supreme Court. And I just want to point out a couple of things about that case. In that case, the Supreme Court said that in order for the county to argue that it has the authority to set aside the tax deed under Chapter 75.22, and that's the statute on which we would rely to rescind or walk back this tax deed, it would be required to show the property was inequitably taxed, resulting in the property owner paying more than its equitable share of the tax. The case also stands for the proposition that the definition of the groundwork being defective, or there being a defect in the groundwork of a tax, is it's a defect or irregularity that necessarily affects the principle of the tax and shows that it must be unjust and unequal as an illegality or irregularity that results in an inequitable burden. So I don't agree necessarily that it's simply the process that is to be looked at. I think it has to do with the valuation and whether it produces in the principle of the tax an inequitable burden to the owner. That's my understanding of that case. And without some further proof that there's an inequitable burden and that the tax is unfair, or the groundwork, as the court said, is faulty here or defective, I just don't know legally that this is allowable. I'm all with you on the equities here. I'm all with you on the fairness and the fitness and decency of Mr. Simmers. I'm with you 100%. I am concerned about the legality of walking back a tax deed without an ordinance in place, one that this county had for a time and then rescinded for reasons I can't answer because I wasn't here. But that's my concern and my reading of the Jackson case. So essentially, I think it means that there has to be a basis to do this, whether it be a notice defect, which there is none here, and that's conceded, or there be a defect in terms of that the inequity created by the principle of the tax being too high or improper. And there's not enough of a showing here, nor is this a body to make that kind of a determination, either by guesswork or by being sympathetic to one side or the other. So that's the position of the County Corporation Council on this.
Thank you, sir. Supervisor Rose, you have the floor.
All right, thank you. I would move to refer this issue back to the Finance Committee. If I get a second, I would like to speak to that.
There is a second.
All right, thank you. I'm suggesting that this issue go back to the Finance Committee so that we can establish a policy and see if this particular issue fits within that policy. I understand this is the only person that you've heard from. It's not the only person that has ever come before the county clerk's office or probably the county executive's office and pled their case, but we're told that, Kenosha County just doesn't do that when they've taken the property by tax deed. Can we draw up a policy which allows this, which you will be satisfied with to apply to other individuals? I don't know, but we can give it a shot and see if it meets that. But it's a policy that would have to be uniform and not have any individual, not drafted so that it is in benefit only one particular person who comes before this committee and has a very sympathetic case to offer. It has to be a policy that is one which is uniform and applies to everyone, be it the developer, the retired veteran, or the widow, or anybody else. So that's what I feel about this. So I would suggest that we refer it back to the committee. We'll discuss the policy and see if we can come up with one that fits the situation. I think we're making a very bad mistake by singling out one person and saying, we'll give it to you, but what about the developer who comes before the committee and says, these are my reasons, and we don't think that's very sympathetic. That's exactly the kind of situation you want to avoid. It's got to be uniform. That's why I support the referral back to consider the much broader policy issue. Thank you.
Thank you, Supervisor Rose. So I'm going to clear the board because lights were going off and there were some on before. So supervisors, I want to speak. Right now, we're going to be on the referral back to the committee to take a look at this broader spectrum. So any supervisors would like to comment, then you can do it. So Supervisor Ron Frederick.
Mr. Chairman, I'm going to vote against the referral. I think you either vote this one up or up down. A gentleman's going to be evicted from his house in about a month, so you might as well get it out of the way. I think we should not refer this back. I think we should vote on it tonight, and that's it. I'm not going to vote for a referral.
Okay, thank you. So just so I'm clear, if this does get referred back to the committee, would there be an extension for Mr. Simmer? Could there be an extension for him? Yes. Okay, hold on. There could.
The matter can be adjourned. I've already indicated to the committee, and I would to the board, that on behalf of the county, I would ask for an adjournment, and I would probably ask for at least until January to give enough time to develop a policy.
I want to make sure the body knows that. Thank you. Supervisor Gens, you have the floor.
Thank you, Mr. Chairman. It's ironic. That's the exact motion I made in committee and then withdrew it because his fees will continue to go up while we create a policy. So it didn't have the votes on the finance committee. The finance committee decided to just move forward with it. I was in favor of postponing it till January and freezing his costs at what they are now, and Corporation Counsel told me that that was illegal. So by then, he will rack up about $3,000 more worth of payments. Well, I just saw it go up. We had a note in the Finance Committee that as of the end of August, it was 11,000, and now it's 16, and we're in the middle of November. So extrapolate that out, and that'll give you an idea. So that's why I decided I was not going to move forward with that. So the committee did discuss that. The committee did talk about this at length and supported it 6-1. So I will not be supporting deferring it as well. I agree we need a plan, and that's what we put on the next agenda. And anybody here who is very concerned about having a plan is welcome to come to that meeting and offer their input. Thank you.
Thank you, sir. Supervisor Poole, you have the floor.
I agree with Supervisor Frederick. Let's get this done tonight. Thank you.
Thank you. Supervisor Uhas, you have the floor.
Thank you, Mr. Chairman. Mr. Simmers reached out to me back in late September about this issue, and I talked with Corporation Counsel, and I gave him some guidelines and some direction. The one thing I haven't heard from Mr. Simmer is the appraisal of his property, because that's what he's going off of. He's saying it's an unfair tax burden because of the appraisal. Associated Appraisal, who does Bristol's revals, just did a reval. Their open book session that any resident could go to discuss a reval or an assessment. There was that opportunity about a month ago to do so. There's also going to be a board of review that should be coming up that Mr. Simmer should be attending to have his property properly assessed. If that's his argument as to why he fell into what he did and his argument for this to continue on. So I do encourage you, Mr. Simmer, you need to talk to Associated Appraisal. Get a property card. They'll provide that to you. Find out about when the board of review is going to be and make sure you're there so you can question that, because that's where your appraisal is going to change. That's where your assessment is going to change. We don't do those appraisals. That is done through Associated Appraisal, who is contracted through the Village of Bristol. Thank you.
Thank you, Supervisor Uhas. Supervisor Sklitsky, you have the floor.
Thank you, Mr. Chair. Just for a point of clarification, if Corp Counsel Moyer could clarify that.
Sure.
I think I heard him say that without an ordinance in place, this resolution wouldn't be enforceable, but maybe I misunderstood him.
No, I just don't think that there is authority under the law to undo a tax deed without some basis, whether it be defective notice, voiding the deed, or a defect in the groundwork of the tax, which is, as I read before, the definition of the Supreme Court is that, it's some inequity in the principle of the tax that makes it an unfair burden on the property owner. And absent that, and absent an ordinance that we once had, allowing this to be sold back essentially, for the amount of taxes and costs due, I don't know of the authority in the law to undo a tax deed in the manner that's being suggested tonight.
So, and I understand about the fact that if you got it reassessed, there might be the defect or the imperfection in how it was assessed, and that would then lend credence to Mr. Simmer's argument. But if this resolution went forward, would we indeed as a body or as the county be able to quitclaim deed it back to Mr. Simmer or not? That's where I'm just uncertain about.
If this body voted to approve the resolution, it asks that we quitclaim it back to him, or it requires that we quitclaim it back to him.
Once the fees are paid, correct?
Pardon?
Once the fees are paid.
Right, upon payment of, right, upon meeting the other requirements of the resolution, which is payment of all the taxes and the interest and penalties as well as the cost to the county.
Certainly, and that's enforceable though. That's why I'm a little gray here, because I do understand where the precedent has not been set, and there is not an ordinance in place to allow this. So I just want to make sure we're not following a resolution thinking that we can implement it, but then it gets challenged at some legal level and is reversed.
I suspect that's a possibility. Who would bring the challenge? I don't know, but that's the problem, you see, is that we are subjectively deciding these things. We are deciding kind of that the assessment is improper, essentially, in my opinion, by accepting this and voting for it without really having the expertise or the facts that we need to make such a finding.
Okay, thank you very much.
That's all, Supervisor Kuski?
Yes, thank you, Mr. Chair.
Thank you. Supervisor Gaschke, you have the floor.
Thank you, Mr. Chair. I would be more than happy to support Supervisor Rose's motion to refer this back to committee. As I said in my last statement, I have nothing but compassion and sympathy towards Mr. Simmers, and I would want nothing more than for him to be able to stay in his home, and I'm glad that he has the network of support in place now that he didn't have earlier. That being said, if this is referred back to committee, again, it would have to be, policies would have to be put in place that would be broadly applicable. The only reason I would be voting against this situation tonight would be because I don't think that we're authorized to vote in favor of it. But if this were to go back to committee, and if we were able to get policies in place that would be broadly applicable, that would also benefit Mr. Simmers, I would welcome that. So I think that rushing to judgment tonight would be not the right choice, and sending this back to committee to allow more research to be done would be the appropriate action tonight. Thank you.
Thank you, sir. Supervisor Kubicki, you have the floor.
Thank you, Mr. Chairman. I too will be in favor of sending it back to committee. But that being said, can anybody give me an accurate figure, since we can't, we're going to have to add additional taxes to this particular individual moving forward if we go into January, and what that actual figure may be. Because right as of today, or as of the end of this month, it's $16,702.10. So do we have a figure that I could be sharing with the rest of my board mates tonight if we move this to January?
I'll give Deputy Clerk permission to speak on this.
Thank you.
Okay, so what Supervisor Gentz is speaking about, where he said it went up about $3,000 in that short period of time. If you're not looking at the complete numbers on that, the actual tax, that sheet that you're looking at, that says $16,672.10, that is not just the tax or the penalty and interest. That includes we have all the fees of the time spent by Corporation Counsel, the Treasurer's Office, reimbursement back to the county for all that we have put into this, so all of our costs. Okay. So the actual change in which I was trying to figure this out because I didn't, you have a sheet of the new tax.
That's correct.
And the total, what are you looking at?
I'm looking at the total amount due to Kenosha County is $672.10 plus a filing fee of $30 would be added to that.
All right, so in committee you were handed another sheet that had the taxes.
Yes.
Of penalty and interest total. I don't have that because I gave it to all of you guys. Not that.
That's it?
Yes, that one. I have it here. So let me just show you the difference of what actually changed when I went down and printed out what it would be through November from what we were talking about. So it went up $383, not $3,000.
Okay.
So, but it would, if we did go through till January,
yes,
it would probably be another $300 to $400.
Okay. Thank you for that clarification.
More than the
last amount that I have
12,
here.
Right.
Okay.
That the confusing part is this part, but this is what we would request to collect because of the time that the county and the money the county has spent on this property.
Okay, so that being said, so we're talking about another $400, give or take, if we postpone this, vote on it, get something forward in January. Is that correct?
That is correct.
Okay, thank you.
Thank you, Supervisor Kubicki. Supervisor Nordigan, you have the floor.
Thank you, Mr. Chairman. Come January, we roll into a new tax is due, do we not? Is that $17,000+ going to include now the 2019 taxes?
We did do a estimated on the 2019s because those will be due in just a few weeks.
Right.
Or, I mean, that tax bill will come out in just a few weeks.
Right.
And because of the history of the delinquency, we estimated based on the 2018.
So that's in the 17+ thousand by
that's
January,
in
or
the
whatever
16,
it's going to be.
yeah. Mm-hmm.
Okay, and then we're a country of laws, and how we currently have our situation set up, I can't possibly support the resolution. I can support, I guess, delaying it and moving it back to finance to see if there's something they can do that would be equitable for the entire county. I too don't want to see another vet on the street. I just, we're in a tough situation, and I just believe that the way we have it now, we can't possibly support that resolution. I would be supporting moving forward with sending it back to committee. Thank you.
Thank you, Supervisor Nordigan. Supervisor Franco, you have the floor.
Yes, I'd like to call the question, and I'd like to call a question on Supervisor Rose's motion to refer it back to committee.
Call the question by Supervisor Franco and a second by Supervisor Rose. Let me clear the board. It is not debatable, so there's been a call to question. Is there a roll call? Roll call. There's a roll call that's been requested. Yes, if you would like to close debate on this issue, on Supervisor Rose's motion to refer this back to committee, no if you're not. So vote yes if you're in favor of closing the debate, and then we'll be back on the question of referring it to committee. No if you want to continue to debate what we've been talking about. No if you want to continue to still discuss the referral back to committee. Yes if you want to stop this discussion. 18 yes, 4 no. So right now we are on the motion of Supervisor Roses to refer this back to committee. There's been a roll call requested. Yes if you're in favor of referring this back to committee. No if you're not. So it passes 13-9 to refer back to committee. It will be referred back to committee. So moving on.
Communications from Andy M. Bueller regarding future items scheduled before the Planning, Development, and Extension Education Committee.
Refer to PDEC committee.
31, communications from the Finance and Administration Committee, agreement between Kenosha County and the City of Kenosha for the transfer of tax parcels and subsequent development of lands.
Refer to Finance committee.
Claims, Mark Clark, vehicle damage.
Refer to Corporation Council.
Approval of the November 5th, 2019 public hearing, organizational and annual meeting minutes, and the November 6th, 2019 regular county board meeting minutes by Supervisor Grady.
Supervisor Grady, you have the floor.
Thank you, Mr. Chairman. I move to approve November 5, November 6 minutes as presented.
Motion by Supervisor Grady, second by Supervisor Nudo. All those in favor say aye. Aye. Can I have a motion to adjourn?
Motion to adjourn.
Motion adjourned by Supervisor Nudo, a second by